Our next speaker is Yofi Tirosh. So here we're going again into another entirely different field. Yofi is from the School of Law, and rather than go into a long introduction, we're going to hear about legal aspects of things that have to do with food, form, and gender, I think.
Thank you. So we don't do presentations in the law school, so bear with me by just hearing me talk. My aim this morning is to provide a brief overview of how lawyers think of food security. So really it's 15-20 minutes on food security in legalese. My presentation will have three parts. I'll open with an introduction of the legal meaning of the term food security. I'll continue with a short review of manifestations of this term in different countries in the international law and in international law, and how they define food security, how they protect food security. And I'll end with the status of this term in Israel. So how is food security defined? Several international law documents state that food security exists when all people at all times have physical and economic access to sufficient, safe, and nutritious food to meet their dietary needs and food preferences for an active and healthy life. So when people lack access to sufficient amount of nourishing food, they suffer from lack of food security. This can be expressed by reliance on socially unconventional ways of gathering food, of achieving food, such as beggary or searching in waste bins. It could be expressed by consuming stuff that is unworthy of eating. So unlike starvation, lack of food security is not life-threatening in the immediate sense, but impairs everyday functioning and involves social exclusion. In the first week of law school, Law 101, you learn that rights are the building blocks of law. So if you want food security to matter, you need to define it not as the value of food security or the interest of food security or the principle of food security, but as the right to food security. This terminology will assist you in getting actual remedies in courts that review legislation, that struck down administrative acts, and indeed the usage of the term right has entered national and international law in the context of food security. The right to food security has been recognized as essential to ensure democracy and protect human rights and fundamental freedoms. International law documents recognize that while it is important to provide ad hoc assistance to ease the plight of areas struck with disasters such as wars or drought, it is not a long-term solution to the underlying cause of food insecurity. So we see here all the time this movement between starvation and hunger, immediate emergency needs, and the long-term policy-oriented interests that are manifest more in the right to food security than in the right to food itself. UN documents state that, at least today, the roots of the problem of hunger and malnutrition are not lack of food, but lack of access to available food, inter alia because of poverty by large segments of the world's population. So it is treated as a problem of distribution more than as a problem of production. In legal terms, the question is one of distributive justice, a just allocation of resources among regions, nations, within different segments of the population within a nation, and even within a family and between ages and genders. But this is where things get complicated. I said before that rights are a very strong tool or weapon or instrument for achieving remedies, but not all rights were created equal. In legal theory, there is a traditional divide between civil and political rights on the one hand and social and economic rights on the other hand. Civil and political rights include rights such as the right for free speech, religious freedom, right to free association, the right to privacy, freedom of movement, property rights, contractual freedom. Social and economic rights include rights such as the right to accommodation, the right to education, the right to health, and the right to food security. Now, traditionally, the former rights have been recognized as more important for democracy and for human rights, and as more enforceable in courts. They're considered negative rights. They're negative in the sense that the government only needs to refrain from interfering with the fulfillment of the right. That is, there is no positive duty to provide anything to the citizen in order to guarantee the right. Social and economic rights, on the other hand, are considered positive because they cast actual duties for intervention and material allocation to guarantee the right. But many argue, myself included, that this is a false dichotomy. Civil and political rights cost money too. For example, when you send police troops to protect a controversial demonstration, that costs money, right? It's tax money that goes to the police troops. Or when you build a ramp to a ballot to enable a person on a wheelchair to exercise the right to vote, you invest money. This is money invested in protecting civil and political rights. I'll expand on the Israeli law later, as I said, but for now I want to point out that only 2 days ago, on Tuesday, in the last decision that the former Chief Justice of Israel, Dorit Beinish, gave, if you recall from the papers, it was a decision about how the law denies social benefits from women who use cars. Another more general aspect of this ruling was that the court in Israel has very bravely and with a lot of vision undid the division between social and economic right and civil and political right. The court declared that the status of those rights in Israeli law today is the same, and not many legal systems in the world did this, so it's a major achievement for Israeli law. Another perceived dichotomy between the two kinds of rights is with regard to their scope. Civil and political rights are considered as having a clear-cut boundaries. Either one has the right to free speech or one doesn't have this right. Either the right to free speech has been violated or it hasn't been violated. It's a kind of yes-no or 0-1 logic. Social and economic rights are considered much more open-ended. They're a matter of degree. They're contextual. For example, the right to health in a developing country will not have the same content and meaning as the right to health in a developed country. The scope of the right depends on social standards, material conditions, economy, technology, prevailing norms and practices, etc. So social and economic rights are much harder to bring to court and receive remedy. Courts are not built for policy. It is hard for a court of law to say whether allocation of X fund for providing Y caloric value per citizen is constitutional or not. Socioeconomic rights, then, are a sensitive area for potential clash between governmental branches. Courts on the one hand and parliaments and the executive branch on the other hand. Courts might be accused in overstepping their authority with regard to the other branches. I'll not expand further on this point, but it is important to understand the scope of the challenge and the backstage drama when we talk of the right to food security as a social right. So, after those general comments, let's look at actual legal systems. If we review the constitutions of the world, we find in 22 countries that there is a specific recognition of the right to food. Sometimes it's the right to food of particularly vulnerable populations, such as children or the elderly. At other times, it's a general right to food. Just as an example, the South African constitution states that everyone has the right to have access to sufficient food and water. Or if we look at the Indian constitution, we see that it has taken a different approach. Rather than giving an individual right to every citizen, it states the government's duty. So the constitution reads, the state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as amongst its primary duties. This, you see, is kind of a more mushy and open-ended language, and the provision is not enforceable in court. It only has the declarative importance. But there is also indirect recognition of the right to food, where the right to food has been recognized as part of the right to dignity. We find the right to dignity in many, many more constitutions, and a lot of them said that part of human dignity includes the right to food. So just to illustrate how lawyers think about this, it matters how you conceptualize the right to food. If we tie food to the right to life, this would only allow us to protect people from starvation. But if we tie the right to food to the right of dignified existence or to the right to health, we can start talking about nutritional food, about food security in the long term, a balanced diet, adequate food, etc., etc. What about international law? Canonic conventions and treaties recognize the right to food. The 1948 Universal Declaration of Human Rights says that everyone has the right to a standard of living adequate for the health and well-being of himself or his family, including food, clothing, housing, etc. But the most elaborate recognition of the right to food and most conceptually deep is from the 1966 Convention of Economic, Social, and Cultural Rights. Article 11 states that everyone has the right to adequate standards of living, including the right to food. State parties commit to take measures, and now I quote, it's a little long, but bear with me, to improve methods of production, conservation, and distribution of food by making full use of technical and scientific knowledge, by disseminating knowledge of the principles of nutrition, and by developing or reforming agrarian systems in such a way as to achieve the most efficient development and utilization of natural resources, while taking into account the problems of both food importing and food exporting countries to ensure an equitable distribution of world food supplies in relation to need. So as you see, it's a very holistic vision in addressing the problem. Although, as you can see, even in international documents that I want to say something else before that. Sorry. We see the right to food then recognized in international documents for more than 60 years, since 1948. But it didn't really have much meaning until the late 90s, where intensive UN activity tried to give it bite, to give it actual meaning. So a major boost to this right was given in 1996 when the right to food security has been recognized as a human right in the Rome Declaration on World Food Security. The recognition has led to further UN activities, monitoring and decisions on the issue by the UN FAO. But as you may have noticed, even in the international documents, the language is national. That is, it refers to the state's obligation to its own citizens and residents. That's how it is in international law. Each state says, I will do this and that for my citizens. So before I return to the national level, I want to stress that there are some attempts to work in the international level and remain there in a more holistic or regional perspective. For example, in removing trade obstacles, in creating intellectual property norms that protect indigenous knowledge, or in setting uniform standards for what should be considered appropriate edible food. So what happens when this right arrives to court? How do courts deal with this right? A few examples, and I should mention that I drew many of them from a wonderful article by Christian Curtis, who is a human rights officer in the UN. So in 2003, India's Supreme Court held that the state failed to create appropriate schemas to prevent starvation and risk of starvation, even when it had grain stocks available. So we have a situation here which is dramatic. People are hungry, and the court says to the state, you have to change your policy. You have extra grains. You have to design a policy that will prevent hunger amongst your citizens. The court issued interim measures to mandate the state to implement the famine code, especially in relation to vulnerable groups. In some cases, for example, in Germany, the right to food was recognized as part of a discussion of the limits of the state's powers to tax. The German Federal Constitutional Court held that the state's taxing power cannot extend to material means necessary to cover the existential minimum, which includes food needs. The right to food also comes up in cases of access to land, especially of indigenous people. The Inter-American Court court has held, for example, that access and security of legal tenure to ancestral land is particularly important for indigenous people as a means to survive, to obtain food, and to carry out traditional productive activities. The right to food security has also been recognized as including the right to secure food. For example, in Bangladesh, the Supreme Court ordered the government to return back to the country of origin a shipment of 125 tons of powdered milk imported from Estonia because of its radiation levels that were unsafe. The court said that the government's duty to protect its people's right to life expands further than protecting life and limb in the physical sense and includes the protection of health and normal longevity of an ordinary human being. Consumer protection law also have a significant role in the right to food. We should also mention intellectual property law, as well as antitrust law. All of these areas affect the right to food. The final part of my presentation will address Israel. So in 2005, Israel's Supreme Court reviewed a petition against the cutbacks of social benefits such as income security. It's a petition by an NGO called מחויבות לשלום וצדק חברתי. It held that the government is obligated to guarantee its citizens' right to dignity, but the court defined dignity very narrowly. The duty of the government is to provide material means for minimum conditions of existence. The court said that the government needs to guarantee, among other things, that citizens will have food and drink sufficient for existence. In our context, although the question did not come up directly, it means that the government has a duty to save its people from starvation, but it would be harder to argue under current law that this duty includes the right to diverse and balanced nutrition. Now, as far as I could trace back, the term food security first appeared in Israeli legal discourse in 2007, very recently, in a petition of Latet, an Israeli humanitarian aid organization, to the High Court of Justice. Latet asked the High Court of Justice to order the government to recognize its responsibility towards 200,000 families in Israel who rely on soup kitchens to survive. The petitioners make an important distinction between the government's duty to treat long-term structural poverty and its duty to address and hopefully short-term symptoms such as poverty, which manifest in lack of access to food. However, the petitioners framed the notion of food security very narrowly as the right not to be hungry and as the right to minimal food security. In replying to the petition, the government did what it often does. It said to the court, instead of deciding the petition, let's start a committee. The committee will review recommendations for needed policy changes. The petitioner said, okay, we'll wait. They withdrew the petition, so we don't have a court ruling on this petition. However, surprisingly and impressively enough, the committee chaired by Izikovich, the CEO of the Welfare Ministry, did a really serious and elaborate work. And it recognized that there is a severe food security problem in Israel. A 2003 survey found that 22% of Israel's population suffer from food insecurity. We heard often happens in Israel. The committee drafted a law with really broad recommendations and authorities to design accountable, viable policy for food security. But when the law arrived in the Knesset, the Treasury, or should I say the Treasury boys, said, sorry, anything that costs money is not going to be included in this law. So now we have fresh out of the oven a law with a very impressive name, חוק המועצה הארצית לביטחון תזונתי, National Council for Food Security Act. but with no actual power. It establishes a council that will make policy recommendations, but it has no authority or budget, and stipulates that the Welfare and Social Services Minister are responsible to create a national program on food security for Israelis. The law has entered into effect only 2 weeks ago, so it remains to be seen what, if any, will happen with it. I'm ending in a minute. In the context of food security, I should also mention the mandatory daily school meal law that we have here for schools that have a long school day. And in the past 2 decades, there has been attempts to constitute a basic law on social and economic rights in Israel. In this basic law, there is a specific article on food security and the right to food. Who knows, maybe because of Tuesday's decision, this law will get a boost. I'll end with a pessimistic note and an optimistic note. So pessimistically, it's astonishing to realize, if you look back at all I've said until now, to realize that most of the court's cases and laws that I mentioned focus on the final stage of the food chain, getting the existing food to the mouths of those who do not have access to it. The law does not deal with long-term policies such as land use and zoning, biodiversity, trade chains, etc., etc. This, I think, reflects an inherent limitation of law, and here I'm not a typical lawyer that thinks that law is everything. Law is not policy. It can be very useful in the edges, in the extreme, but we need scientists, nutritionists, welfare experts, economists to make sound policy that will ensure food security. On an optimistic note, some of the language in the international legal documents is very holistic and broad. Just to read you one paragraph, the right to adequate food shall not be interpreted in a narrow or restrictive sense which equates it with minimum package of calories, proteins, and other specific nutrients. The precise meaning of adequacy is to a large extent determined by prevailing social, economic, cultural, climatic, ecological, and other conditions. There is a mention of the need to take into account as far as possible perceived non-nutrient-based values attached to food and food consumption. So such language indicates perhaps that the law can and might well think of this right more broadly. We haven't talked about the gender effects or characteristics of food security. We haven't talked about water, but I need to leave something for the next conference. Thank you very much.
Maybe time for, even though we don't have the time, one question. I'd like to make a comment. I think you've opened up all sorts of issues here that has to be broadened and talked about on the legal, which is a sort of thing that we don't normally talk about. And I think it would be, my suggestion would be that we have to talk about it, think about another conference where we'll talk about the holistic questions of food security and law. Thank you. That's the end of this session. I'd like to thank all our speakers.